Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Happy Halloween and happy day before election! Quite the week this week. Earlier this week, I decided to review some really important decisions on TPS and detention that originated in district court because of a lack of petition for review cases, only to have the courts publish 4 decisions on Friday afternoon. C'est la vie. We've got 8 cases this week, and we'll proceed in circuit order. Also, some exciting podcast news. After 6 months and some back and forth with the U.S. Patent and Trademark Office, Immigration Review is now a registered U.S. trademark. So, Executive Office for Immigration Review, consider this your cease and desist notice. Your name is confusing my listeners. Let's get to the first case. First is matter of PAC, published by the Board of Immigration Appeals. This is a case about Form I-130 petitions and fraudulent marriages. So this BIA case actually originates at USCIS and not an immigration court, because the BIA has authority to review USCIS's denial of an I-130 petition. As many of you know, an I-130 petition is the first step required to adjust a lawful permanent resident, or LPR, status. An I-130 petition is simply recognition by USCIS that a qualifying relationship exists between a non-citizen and a family member, such that the non-citizen is potentially eligible to adjust to LPR status. In this case, like in most cases, that qualifying relationship is Mr. Pak's marriage to a U.S. citizen. If the I-130 petition is approved on that basis, meaning that USCIS recognizes that Mr. Pak's wife is a U.S. citizen and that they have a valid marriage, Mr. Pak will become immediately eligible to adjust to LPR status, provided he satisfies the other provisions of INA Section 245A. Here's the thing, though. Another provision of the INA, Section 204C, bars USCIS from approving an I-130 even where a valid marriage exists, if the non-citizen, in relevant part, quote, has previously sought an immediate relative or preference status as the spouse of a U.S. citizen by reason of a marriage determined by DHS to have been entered into for the purpose of evading the immigration laws, or 2, if DHS has determined that the alien has attempted or conspired to enter into a marriage for the purpose of evading the immigration laws, end quote. Now in this case, Mr. Pak indeed had a previous marriage, and his previous wife filed an I-130 petition on his behalf. But USCIS never made an express Section 204C finding as to that petition. Rather, and although USCIS expressed some concerns about fraud, USCIS denied the first I-130 petition for Mr. Pak and his ex-wife's failure to meet their evidentiary burden. Mr. Pak remarried, and his new wife filed a new I-130 petition many years later. USCIS denied the I-130 petition as 204C barred. Reviewing the matter de novo, the BIA agreed with USCIS. The BIA noted that under the regulation, all that's required to make a Section 204C marriage fraud finding is that, quote, evidence of the attempt or conspiracy must be contained in the alien's file, end quote. A finding that the prior marriage was entered into for immigration purposes is not required at the time the first I-130 is denied. Rather, quote, Section 204C may be applied based on a marriage fraud finding whenever it becomes evident that there is substantial and probative evidence of an attempt or conspiracy to enter into a marriage for the purposes of evading the immigration laws, end quote. The substantial and probative evidence standard is higher than a preponderance of evidence in that to meet the standard, the evidence, quote, must establish that it is more than probably true that the marriage is fraudulent, end quote. Here, the BIA found that heightened standard met. So Mr. Pak cannot adjust status based on his current, valid marriage to a U.S. citizen. Here's a warning and 2 observations. So it seems to me that after this decision and the BIA's recent decision in matter of Ortega, all clients with prior marriages seeking to adjust status based on a second marriage to a U.S. citizen need to be careful, even if that prior U.S. citizen spouse never filed an I-130 petition. USCIS may take the position at the last I-130 interview that everything is on the table, including whether the first marriage, without even an I-130 petition, was entered into for immigration purposes, thereby making the non-citizen 204C barred. So practitioners, I'd treat the I-130 interview as essentially 2 I-130 interviews in that situation, and assume that the bona fides of both marriages are on the table. And finally, in a footnote, the BIA notes that Section 204C, quote, does not bar the approval of a successive visa petition filed by the same petitioner on behalf of a beneficiary's spouse, end quote. So it would appear that even if a U.S. citizen petitioner files a fraudulent I-130 petition for one spouse, he or she is not barred from filing a legitimate I-130 petition, presumably for a new spouse, in the future. And that is matter of Pak. Next, we've got Velasco Lopez v. Decker et al., published by the Second Circuit on October 27, 2020. This is a case about immigration detention, and it's a big win for non-citizens. Thank you, fellow immigration practitioner David Kim, for the heads up. This case affirms a district court judge's grant of habeas relief to a non-citizen detained under INA Section 236A, the non-mandatory detention provision. It holds that under the circumstances of this case, the government, and not the non-citizen, has the burden to establish that continued detention is warranted. We've never really discussed detention on the podcast, so here's the 5-minute rundown. 95%, if not 100%, of immigration detention centers in the United States are privately owned by large corporations. ICE fills the bed of these private detention centers with non-citizens present in the U.S., and then, according to the Second Circuit and ICE itself, pays the private corporations $134 a day per non-citizen. The non-citizens are, according to the Second Circuit, quote, incarcerated under conditions indistinguishable from those imposed on criminal defendants sent to prison following convictions for violent felonies and other serious crimes, end quote. Every non-citizen in the U.S. is potentially subject to immigration detention under the right circumstances. Generally, the legal bases for detention are INA Section 236A and 236C. 236C is the mandatory detention provision, applicable in a wide range of circumstances, including, say, for non-citizens convicted of aggravated felonies. If subject to mandatory detention, a non-citizen, even if the non-citizen has been in the U.S. for many years, has completed his criminal sentence, and has completely rehabilitated himself while in prison, must remain detained until the immigration proceedings conclude, at which point he's either released or removed from the United States. INA Section 236A, on the other hand, is for everyone not covered under Section 236C, although with one big caveat. Last year, in matter of MS, the Attorney General held that all non-citizens deemed applicants for admission, which includes all asylum seekers at the border and even those who are found by an immigration judge to have a credible fear of persecution, are never eligible for bond before an immigration judge. The policy was enjoined by the ACLU's Padilla v. ICE lawsuit, but it was vacated in part and remanded by the Ninth Circuit. I believe an injunction remains in place in matter of MS, but I'm not 100%. Anyway, back to I&A Section 236A. Sorry. All other detained non-citizens must be released on bond unless an immigration judge deems them a danger to the community or a flight risk. If deemed a flight risk, an IJ should set an amount of bond sufficient to ensure that the non-citizen appears in court, just like what happens every day in criminal court. The President's comments at the last debate notwithstanding, many non-citizens appear for their immigration court hearings, and many have very high IQs. Under I&A Section 236A, the non-citizen has the burden to establish she's not a danger, and that she's not a flight risk. If the non-citizen fails to meet that burden, she can remain detained for the entirety of immigration proceedings and any appeal, even if she doesn't have a criminal record. And that's what happened to Mr. Velasco Lopez, an individual who has lived in the U.S. since he was 4 years old, serves as a caretaker for his ill mother, and who had DACA for many years. He was convicted for driving while impaired. He was later arrested for DUI and assault. The charges for these latter two incidents were dismissed, but he was detained, lost his DACA status, and placed in removal proceedings for being present to the U.S. without DACA status or any other status. An IJ twice denied bond, and so he was held for 15 months in immigration prison. Now, bond decisions can't be appealed to the federal circuit courts, so after 14 months, Mr. Velasco Lopez filed a habeas action in U.S. District Court. This is no easy matter. The immigration statutes have a lot of jurisdiction divesting provisions, including for habeas review of detention decisions. And it's pretty expensive to do it. And in 2018, the Supreme Court issued Jennings v. Rodriguez, essentially saying that the only potential basis to challenge immigration detention is to assert a constitutional or legal violation, or to assert that detention is somehow impermissible, quote, under the statutory framework as a whole, end quote. I imagine the Supreme Court will rule on the scope of these final carve-outs relatively soon. In this case, a federal judge found that a constitutional violation had indeed occurred, and that the only remedy was a bond hearing before an IJ, where DHS, and not Mr. Velasco Lopez, bore the burden of proof. DHS was unable to meet that burden at the third hearing, and Mr. Velasco Lopez was released on a relatively small bond amount of $10,000. On the government's appeal, the Second Circuit affirmed the District Court's grant of habeas relief because under the Supreme Court's Zadavius v. Davis decision, a case I can never say, there are, quote, important constitutional limitations, end quote, on the government's ability to detain non-citizens during and after removal proceedings. Here, Mr. Velasco Lopez raised a cognizable, quote, due process challenge not to his initial detention, but to the procedures that resulted in his prolonged incarceration without a determination that he poses a heightened bail risk, end quote. This passes the jurisdiction-stripping provisions of the I&A and the Jennings decision. Applying the Supreme Court's 1976 Matthews test, the Seventh Circuit, like the District Court judge, ruled that Mr. Velasco Lopez suffered a constitutional due process violation. Importantly, quote, where the Supreme Court has upheld detention during the pendency of removal proceedings, it has been careful to emphasize the importance of the relatively short duration of detention, end quote. 15 months does not cut it. According to the courts, the appropriate relief was a bond hearing, where ICE needed to show by clear and convincing evidence that Mr. Velasco Lopez needed to remain detained. And according to the Second Circuit, this decision aligns with the decisions out of the Third and Ninth Circuit. So, after 15 months and $60,000 government dollars, as estimated by the Second Circuit, Mr. Velasco Lopez was released from immigration detention. Congratulations, Mr. Velasco Lopez. Here are 3 more observations. How about this from a footnote, Second Circuit practitioners? Quote, in this circuit, Section 236A also applies to individuals who are subject to reinstated orders of removal during the pendency of withholding-only proceedings, end quote. Remember to file your bond motions. Next, the Second Circuit noted that it was the Immigration Service following IRA-IRA in 1997 and not Congress that created regulations implementing for the first time, quote, a presumption of detention, end quote, against non-citizens, and that requires non-citizens to have the burden at their bond hearings. So, future non-Trump administration, just a heads up, regulations can be changed. I leave you with a final quote. Quote, when the government incarcerates individuals it cannot show to be a poor bail risk for prolonged periods of time, as in this case, it separates families and removes from the community breadwinners, caregivers, parents, siblings, and employees. The government articulates no public interest that any of this serves, and we see none. End quote. And that is Velasco Lopez v. Decker et al. Next, we go to the Fourth Circuit, with Amaya-De Sicaran v. Barr, published on October 30th, 2020. This is a case about asylum, domestic violence, and matter of AB. Ms. Sicaran is from El Salvador, entered the U.S. unlawfully, and was found removable many years later under INA Section 212A7AI for not possessing valid documents at the time of her application for admission. She applied for asylum, withholding, and torture convention protection in her 2013 removal proceedings, claiming she had suffered persecution from her husband on account of her membership in the particular social group, quote, married El Salvadoran women in a controlling and abusive domestic relationship, end quote. See, Ms. Sicaran's husband was in the Salvadoran military, sexually abused her terribly, tried to take her children from her on multiple occasions, and threatened to kill her. When after a particularly violent incident, a complaint was finally filed by Ms. Sicaran and her cousin, soldiers allegedly beat the cousin. No legal action was ever taken, and Ms. Sicaran fled to the U.S. Now, at the time of the removal proceedings, the asserted particular social group was much more viable due to the BIA's decision in matter of ARCG. But the IJ held that Ms. Sicaran was not a member of the particular social group because she had actually left her husband in El Salvador and even entered into a custody agreement for their children. By the time of the appeal, Attorney General Jeff Sessions had vacated matter of ARCG with matter of AB, and the BIA held, de novo, that the asserted particular social group was no longer viable. So squarely before the Fourth Circuit is whether matter of AB is legit, and the Fourth upheld key parts of matter of AB with this decision. It rejected Ms. Sicaran's particular social group, deferring to matter of AB's, quote, anti-circularity requirement, end quote, under which the, quote, proffered particular social group must exist independently of the harm asserted in an application for asylum or withholding of removal, end quote. Because Ms. Sicaran's particular social group of married Salvadoran women in a controlling and abusive domestic relationship does not meet this anti-circularity requirement, the Fourth Circuit held that it did not constitute a viable particular social group. And, because the evidence doesn't show that the Salvadoran government acquiesces to domestic violence, the Fourth Circuit also denied the Torture Convention claims. Here's just two more quick practice pointers. First, the Fourth Circuit refused to review the new particular social groups asserted for the first time on petition for review after matter of AB's publication, because non-citizens must assert their proffered particular social groups before an immigration judge first. And in this vein, the Fourth Circuit did condone the fact that asylum applicants, quote, often raise multiple alternative grounds before the IJ to guard against the possibility that one is non-cognizable, end quote. So don't be afraid to assert many particular social groups that match your client's case. It may save it. And just a heads up, under the Ninth Circuit's recent en banc and unanimous Torres v. Barr case, published on September 24, 2020, this case actually should have been terminated, because Section 212A7 is not the proper charge for individuals who have physically entered the U.S. unlawfully. Just saying. And that is Amaya-De Sicaran v. Barr. Moving on, we have Londono-Gonzalez v. Barr, published by the Fifth Circuit on October 26, 2020. This is a short case about motions to reopen and due diligence, with a lot packed in. Mr. Londono-Gonzalez was ordered removed in 2000 based on his having been convicted of an aggravated felony. He was not removed, and 16 years later filed a motion to reopen proceedings based on the BIA's 2014 decision, Matter of Abdelghani. In Abdelghani, the BIA definitively laid out just what types of non-citizens remain eligible for INA Section 212C relief, a friendly form of relief that Congress got rid of in 97, but which has been the subject of lots of litigation and at least 2 Supreme Court decisions. Mr. Londono-Gonzalez argued that after Abdelghani, he was eligible for Section 212C relief, which would thereby allow him to remain in the U.S. with the green card that he lost in 2000. He therefore requested that the IJ and then the BIA reopen proceedings so that he could apply for Section 212C relief. The problem is that such motions to reopen must be filed within 90 days of a final order of removal. As such, Mr. Londono-Gonzalez asked the agency to equitably toll the 90-day deadline for approximately 16 years, up to the date that he filed his motion. The IJ and then the BIA denied, finding that Mr. Londono-Gonzalez had not acted with diligence to file his motion to reopen, as required for equitable tolling. The Fifth Circuit initially affirmed, holding that because Mr. Londono-Gonzalez had been convicted of an aggravated felony, INA Section 242A2C divested it of jurisdiction to review the issue. That turned out to be incorrect, as last term the Supreme Court held in Guerrero-Lasprilla that INA Section 242A2C does not divest a federal court of jurisdiction to review, quote, constitutional claims or question of law, which include the application of a legal standard to undisputed facts. Here, and back on remand from the Supreme Court, the Fifth Circuit held that the specific point at which the due diligence analysis begins in a case qualifies as such a dispute over which it has jurisdiction. Continuing down the legal rabbit hole, Mr. Londono-Gonzalez argued that the diligence analysis should begin in 2016, because in 2016, the Fifth Circuit held in Lugo-Resendez v. Lynch, notably also following a Supreme Court remand, that motions to reopen are subject to equitable tolling. But the Fifth Circuit disagreed, and instead agreed with the government's position that the diligence analysis in this case should begin in 2012, because in 2012, the Fifth Circuit held in Carranza de Salinas v. Holder that individuals such as Mr. Londono-Gonzalez may be eligible for Section 212C relief. The Fifth Circuit so held even though it tacitly acknowledged that prior to Lugo-Resendez in 2016, it would have rejected Mr. Londono-Gonzalez's equitable tolling argument. So, Mr. Londono-Gonzalez cannot reopen his case. Just one more thing. Mr. Londono-Gonzalez was found not to have acted with diligence, largely because, quote, uncertain legal terrain does not create an obstacle that stands in the way of an individual meeting the motion to reopen deadline, end quote. So keep asserting creative, non-frivolous legal arguments, practitioners. You never know what will happen. And that is Londono-Gonzalez v. Barr. Next, we have Morales-Bribiesca v. Barr, published by the Sixth Circuit on October 30th, 2020. This is a case about alien smuggling, another issue we haven't really discussed on the podcast. Ms. Morales is an LPR. In 2007, while returning to the U.S. from Mexico, she presented a fraudulent U.S. birth certificate for her 5-year-old Mexican cousin, Jorge, who was in the car with her. Border officials caught it and placed Ms. Morales in removal proceedings, charging her under INA Section 212A6EI, the alien smuggling inadmissibility provision. As an aside, DHS was able to charge Ms. Morales under Section 212, even though she was an LPR and so would normally be charged under Section 237, because under INA Section 101A13C, an LPR can be treated as an applicant for admission if, among other things, she's, quote, engaged in illegal activity after departing the U.S., end quote. So really, both the applicant for admission and removability analysis all kind of converges into the same factual analysis. Did Ms. Morales engage in alien smuggling? To fight the charge, Ms. Morales claimed that Jorge's mother, also in the car at the time, gave her the birth certificate in an envelope, but that Ms. Morales never looked inside the envelope before presenting it to border officers, and that she assumed it was a Mexican birth certificate. It wasn't. One or two of the CBP officers actually testified in the removal proceedings, which doesn't often occur. The officers testified that during the incident, it seemed like Ms. Morales was lying. Then, according to the Form I-213 that the officers created at the time of the incident, which is like an immigration arrest report, Ms. Morales allegedly admitted everything. An immigration judge believed the officers, admitted the I-213 into evidence, found Ms. Morales not credible, and found that DHS had established her removability by, quote, clear and convincing evidence, end quote. But then while an appeal was pending, the Sixth Circuit decided in Ward v. Holder that in order to remove an LPR, even as an applicant for admission, DHS must meet its burden, quote, by clear, unequivocal, and convincing evidence, which equates to the criminal standard of beyond a reasonable doubt. On remand, the IJ and the BIA found that this heightened standard had been met. The Sixth Circuit affirmed. It held that the officer's testimony was largely consistent with the I-213, and therefore the IJ and the BIA did not err in relying upon that document. Now, to commit alien smuggling, a person must engage in, quote, an affirmative and illicit act of assistance in shepherding someone across the border, knowing that the alien cannot enter the country legally, end quote. Based on the evidence and testimony presented, the Sixth Circuit agreed that providing a false birth certificate and insisting that it belonged to the child met the standard beyond a reasonable doubt. Tough case all around, but two more things. First, Judge Gibbons dissented and would find that DHS did not meet its burden, primarily because the I-213 should have never been admitted, because it lacked indicia of reliability, including the fact that it did not document the questions asked to Ms. Morales, contained vague notes about the answers given, was neither detailed nor chronologically ordered, did not include a video or a transcript, did not indicate Ms. Morales was placed under oath, and did not document the language used to question Ms. Morales. Second, and remember practitioners, when DHS has the burden, and at least in the Sixth Circuit, quote, an immigration judge cannot use an adverse credibility determination to assess whether the government met its affirmative burden, end quote. Didn't help in this case, but argue it in court and on appeal. And that is Morales-Bribiesca v. Barr. Next, we've got Velasquez v. Barr et al., published by the 8th Circuit on October 27, 2020. This is a case about TPS that arises in the district court, so I'll be brief, because the most important part is the holding, and the holding is this. Quote, a non-citizen who entered this country without inspection or admission, but later received temporary protected status, or TPS, may adjust her status to lawful permanent resident status, end quote. This is because, as the statute makes unambiguously clear, the receipt of TPS qualifies as having been, quote, inspected and admitted into the United States, end quote. This is a big deal. There are currently over 300,000 individuals in the U.S. with TPS. The Trump administration has terminated TPS for about 200,000 of them. Those decisions have been challenged and are pending in district court and in the appellate circuits, but they may of course ultimately fail, meaning that those 200,000 individuals would be subject to removal from the United States. At the same time, immigration law allows non-citizens who are married to a U.S. citizen or who have a U.S. citizen child over the age of 21 to immediately adjust to LPR status, but only so long as the non-citizen has been inspected and admitted or paroled into the United States. Many TPS recipients initially came to the U.S. unlawfully, so they were not, at least at first, inspected and admitted or paroled, meaning that even if they have a U.S. citizen spouse or child over the age of 21, they could not adjust to LPR status. However, the 6th, 9th, and now 8th Circuits have held that the receipt of TPS is an inspection and admission, meaning that those TPS beneficiaries with a qualifying relative can adjust to LPR status. Unfortunately, the 3rd, 11th, and I believe 5th Circuits have held otherwise, as has USCIS's Administrative Appeals Office last year in matter of HGG. And that, dear listeners, is the long-forgotten circuit split gong, back with a vengeance. So, TPS holders with a qualifying relative living within the 6th, 8th, and 9th Circuits can adjust to LPR status. And for TPS holders with qualifying relatives in removal proceedings everywhere else, even in the 3rd or the 11th Circuit, practitioners should consider making the argument and preserving it, because with a circuit split like this, a Supreme Court decision may be coming in the next few years. For completeness' sake, Judge Loken dissented. 2 more things. First, the 8th Circuit didn't grant Chevron deference to matter of HGG because it held that the statute is unambiguous, meaning that deference doesn't apply. That's a strong argument against matter of HGG, even in districts where an appellate circuit hasn't yet ruled on the issue. And also remember, matter of HGG has little to no legal force in immigration court because the AAO doesn't bind immigration judges. Second, this decision does not address the sub-issue of TPS holders with qualifying relatives who have departed the U.S. on advance parole and re-entered the U.S. Now, USCIS very recently has taken the position that even though such individuals are paroled back into the U.S., they have not been paroled as required under INA Section 245A to adjust status, and therefore cannot become LPRs even if they have a qualifying relative. USCIS's decision in this regard has already been challenged in many districts, and I believe one district court has enjoined USCIS from implementing the policy nationwide. But in any case, the whole issue is irrelevant in the 6th, 8th, and 9th Circuit, because again, TPS holders in those circuits have already been inspected and admitted simply by receiving TPS. They don't need a parole. Immigration law is a doozy. And that is Velasquez v. Barr et al. Turning to the first of 2 Ninth Circuit decisions, we have Velasquez-Rios et al. V. Barr, published on October 28, 2020. This is a case about the immigration effect of the California legislator's passage of Cal Penal Code Section 18.5, and it's a bit of a bummer for non-citizens. This decision upholds the BIA's 2018 decision in matter of Velasquez-Rios, by the same name, in the same case. Here's what's up. Mr. Velasquez-Rios was convicted of California misdemeanor forgery in 2000, and Mr. Dec, the other petitioner in this case, was convicted of California misdemeanor grand theft in 2000. Both convictions at the time in 2000 allowed for sentences of at least 1 year, although neither individual was sentenced to anything close. DHS sought to remove both individuals in separate proceedings, and because both had been in the U.S. for at least 10 years and had U.S. citizen children, parents, or spouses, both individuals applied for non-LPR cancellation of removal. But an IJ denied the applications in both cases, finding that the convictions were crimes involving moral turpitude for which a sentence of 1 year or more could be imposed. Such a CIMT conviction bars a non-citizen from cancellation of removal. While on appeal in 2015, California passed Cal Penal Code Section 18.5, which makes the maximum sentence for a misdemeanor 364 days, less than 1 year. This is important because many immigration provisions make a non-citizen removable or bar a non-citizen from relief for certain convictions, but only if the conviction entails a criminal sentence of 1 year or more. California knew what it was doing, and it did it. Then, in 2017, California, quote, amended Cal Penal Code Section 18.5 to apply retroactively to all misdemeanor convictions, regardless of whether the conviction was finalized on or before the statute's original enactment date, end quote. So, Mr. Velasquez-Rios and Mr. Dec argued that now they were eligible for cancellation of removal because now their CIMT convictions did not have a sentence of at least 1 year. The BIA said it didn't matter in the published decision matter of Velasquez-Rios, because immigration law requires that the court look at the maximum sentence possible, quote, at the actual date of conviction, end quote. And here the Ninth Circuit agreed. Among other reasons, and admittedly this is a secondary reason, the court stated that, quote, "We decline to give retroactive effect to the California statute in the cancellation of removal context, where it appears that the purpose of the state law amendment is to circumvent federal law." End quote. Federalism shots fired, Ninth Circuit. Federalism shots fired. So, Messrs. Velasquez-Rios and Dec are ineligible for cancellation of removal. Matter of Velasquez-Rios stands. Here are some observations. First, and this somewhat follows Ortega-Lopez v. Barr published last week by the Ninth Circuit, in a footnote, the Ninth notes that it's irrelevant whether the CIMT conviction meets the petty offense exception at I&A section 212A2A III, because all that matters for the cancellation of removal statute is that the non-citizen has, quote, been convicted of an offense under section 237A2, end quote, which simply requires that the possible conviction be for a CIMT and that the possible sentence be over 1 year. Second, to be clear, this decision has nothing to do with misdemeanor convictions obtained after Cal Penal Code Section 18.5 became law in 2015. Those convictions cannot, as a matter of law, satisfy any immigration statute that requires a conviction with a possible sentence of 1 year or more. And finally, it also follows that this decision should in no way affect convictions vacated or altered in compliance with the Attorney General's decision last year in matter of Thomas and Thompson, and should in no way impact the effect of convictions vacated under the Padilla Supreme Court decision or state Supreme Court decisions applying Padilla, based on constitutional Sixth Amendment violations. And that is Velasquez-Rios et al. V. Barr. Finally, we reach the end. Medina-Rodriguez v. Barr, published by the Ninth Circuit on October 30th, 2020. This is a case about the categorical approach and drug trafficking crimes. Mr. Medina-Rodriguez entered the U.S. from Mexico at 6 months old and became an LPR in 1987. He was deemed by an IJ and the BIA to have been convicted of an aggravated felony, as defined in I&A Section 101A43B, a drug trafficking crime. In this case, the Ninth Circuit held that the conviction under California Health and Safety Code, Section 11359, possession of marijuana for sale, matched the definition of an aggravated felony drug trafficking crime at I&A Section 101A43B. The issue in this case was this. At the time of Mr. Medina-Rodriguez's final removal hearing, the California definition of marijuana encompassed more conduct than the federal definition of marijuana, because the California definition included, and I believe continues to include, hemp, while the federal definition does not include hemp under the definition of marijuana. But at the time of the convictions, the definitions of marijuana matched. In this case, the Ninth Circuit agreed with the 2nd, 3rd, and 11th Circuits and held that the relevant definition for the categorical approach is the definition of the state crime at the time of conviction, not the definition of the state crime at the time of the removal hearing. This is so because, in addition to the supporting case law, it, quote, comports with the purposes of the categorical approach, namely, providing the defendant with notice of possible future immigration consequences, end quote. Turning then to whether California Health and Safety Code Section 11359 otherwise matches I&A Section 101A43B, the Ninth Circuit reaffirmed that it does, as it held in 2014 in Roman Suaste v. Holder. The Ninth Circuit so held mainly because a felony conviction under this statute, quote, always involves remuneration, end quote, or the exchange of payments, which is also what trafficking requires. The Ninth Circuit also rejected Mr. Medina-Rodriguez's claim to torture convention protection, rejecting his argument that because he needs to use a wheelchair and has multiple tattoos, some of which are drug-related, he is susceptible to torture by the Mexican government or gangs. Not much more that I can say here, and it's been a long episode, so that's all she wrote. And that is Medina-Rodriguez v. Barr. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.